Ladies and gentlemen, I, Assistant Professor Shushmita Kumari, welcome each and every one of you to this seminar on constitutional mandates of Uniform Civil Code. It is an honor to have such a distinguished gathering of intellectuals, scholars, and legal experts gathered here to deliberate on the crucial topic. The Uniform Civil Code has been a subject of intense debate and discussion in India for several decades. It embodies the idea of common set of civil laws that would be applicable to all citizens, regardless of their religious affiliation. While India is known for its diverse culture and religious plurality, the concept of Uniform Civil Code aims to establish a common ground for personal laws in matters such as marriage, divorce, inheritance, and adoption. Our Constitution, which is the cornerstone of democracy, envisages a society that upholds the principle of justice, equality, and fraternity. Article 44 of the Indian Constitution, a directive principle of state policy, explicitly states that the state shall endeavor to secure for the citizen a uniform civil code throughout the territory of India. Now, the seminar provides us with a platform to explore and analyze various aspects of the Uniform Civil Code from an Indian perspective. Now, we welcome today's guest of honor, Senior Advocate Sanjeev Deshpande sir, as well as Mr. Prakash Salsingikar sir. We also welcome Dr. Rohini Jagtap ma'am and our Vice Principal sir, Kailash Paul sir. Our discussion will cover a wide range of topics including constitutional provisions, historical perspective, contemporary challenges, and possible ways forward. I encourage all of you to actively participate in the session, share your insights, and engage in meaningful debates. It is through such open and inclusive dialogues that we can arrive to a better understanding of the issues at hand and towards finding sustainable solution. I once again extend my warmest welcome to each one of you. Let us use this seminar as a platform to engage in meaningful conversation, promote understanding, and collectively work towards more just and equitable society. Thank you, and I wish you all a fruitful and insightful seminar.
A very good morning to one and all present here. The lighting of the lamp is a ritual that symbolizes the dispelling of darkness and illumination of knowledge. It represents the victory of enlightenment over ignorance and the beginning of a journey towards greater understanding. We are honored to have Senior Advocate Sanjeev Deshpande sir and Advocate Prakash Salsingikar sir, the distinguished individuals, to perform the lighting ceremony along with our beloved Principal Dr. Rohini Jagtap ma'am. I would request all of them to kindly join us on the dais to light the lamp and mark the beginning of this enriching seminar. Let's give a round of applause. Request all to give a round of applause. Before we proceed for the enriching discussions, let's take a moment to felicitate these eminent personalities for their outstanding contributions to the legal field and our society. So first, I would request our beloved Principal, Dr. Rohini Jagtap ma'am, to come ahead and felicitate our guest of honor for today, Senior Advocate Sanjeev Deshpande sir. Request all to give a round of applause. Now I would request Kailash Paul sir to felicitate Advocate Prakash Salsingikar sir. I would now like to call upon our Principal, Dr. Rohini Jagtap ma'am, to welcome our guest and also to address us. Please give a round of applause.
Distinguished Speaker, Advocate Sanjeev Deshpande sir, Senior Counsel, High Court of Bombay, former Assistant Solicitor General of India, Advocate Prakash Salsingikar sir, Bombay High Court, Dr. D.K. Bhusi sir, Chairman of Subhadra Education Society, Advocate Rutuja Bose, Director of AC Society, Vice Principal, teachers, and above all my dear students, a warm good morning to all of you. I am really privileged in expressing my gratitude towards Advocate Prakash Salsingikar for organizing this seminar with your organization, NGO, Dar Se Humdard Tak. It gives me immense pleasure to welcome all of you to this seminar on the current topic of constitutional mandate of Uniform Civil Code. Following the independence, there were differing views on UCC. Some had opinion that UCC would not be practical or preferable in diverse country like India, with so many different religions and sects. While others felt that UCC, on the contrary, would bring a harmony between the various communities. Recently, the Uttarakhand government extended the term of panel headed by retired Supreme Court Judge Ranjan Desai to study the implementation of Uniform Civil Code in the state. According to NIA reports, the panel has visited more than 30 places and has received more than 2 lakh suggestions, which include registration of live-in relationship, increasing the age of women from 18 to 20 years for marriage, equal rights for daughters in ancestral property, the legal rights of LGBTQ community, etc. The Uniform Civil Code seeks to enact a single Indian law that would be applicable to all people irrespective of religion in matters like marriage, divorce, inheritance and the adoption. Indian laws are mostly uniform, like Indian Penal Code, Code of Criminal Procedure, even the civil laws are also uniform, like the Indian Contract Act, Sale of Goods Act, Partnership Act and the Civil Procedure Code. But the personal laws are different for different communities, which still are not uniform. The 22nd Law Commission sought the views and objections of individuals and organizations with respect to UCC. The implementation of Uniform Civil Code in diverse countries like India is in need of hour, and it's a high time to implement what has been dead letter for so many years. However, this topic is very debatable, as it having some pros and cons. The other side of the UCC, the Constitution also guarantees religious rights to the citizens. Yesterday itself, the monsoon session of the Parliament has started, and this topic has become a debatable topic in Parliament sessions also. Of course, this will be the challenging task for the government and every stakeholders, and the most significantly, the people should contribute and provide their valuable suggestions and inputs about the same as the Constitution guarantees. The government should also clear the apprehensions of the people, especially the minorities and the tribals. Assure them that their rights will not be violated, and this process would only make the dispensation of justice much easier and more effective. Keeping in view the vision of our law college, that is to disseminate the knowledge of law and with the aim to provide justice to the society, the college has organized this seminar on this current topic. I know that anyone who can give justice to this topic, the most reliable speaker would be the today's chief guest. And on the behalf of SNBP Law College, heartiest welcome to our today's chief guest, Advocate Sanjeev Deshpande. We are really very grateful to you, sir, for accepting our invitation and instead of your busy schedule. I also extend my heartily welcome to Advocate Prakash Salsingikar for taking initiative and support for organizing today's event. We are very delighted by your valuable presence in our program. I also welcome all the faculties and students to this session. I once again welcome all of you to this program. I am sure that your knowledge will be enlightened, and I am sure that you will enjoy the sessions. Thank you so much. Thank you.
Thank you, ma'am, for your valuable words. Now, I would call upon Sanika to come on the dais to introduce our chief guest for today and let her address the crowd.
Thank you, Sajjana. It is my pleasure to introduce our chief guest, Advocate Sanjeev Deshpande, sir, who has graciously accepted our invitation to join us today. Sir is highly accomplished individual in the field of law since 1989. He is designated under Senior Advocate by Honorable Bombay High Court from 16 February 2020. He also worked as the Assistant Solicitor General of India at High Court Bench, Aurangabad, since 2014 to 2020. He also served as a panel advocate for some prestigious organizations. Let me name a few of them, like Pharmacy Council of India, University Grants Commission, Indian Railway, Central Board of Secondary Education and Municipal Council, and he also appeared for CBI and ED. He has conducted over 100 session trials and over 50 reported judgments on various subjects. He has also worked as a special public prosecutor and secured conviction of almost 25 accused in Shewari rights case. He also appearing in various cases with respect to subject intellectual property rights before the High Courts and District Court. He also delivered lectures on various topics on All India Radio and Maharashtra National Law University and also in other institutions. I can go on and we still feel short of a time. We are honored to have Advocate Sanjeev Deshpande sir with us today to share their insights and experiences with our students and faculty. On behalf of our college community, I would like to extend a warm welcome to Sanjeev Deshpande sir. I am sure that his interaction with our chief guest will be valuable learning experience for all of us. With that, I invite Sanjeev Deshpande sir to come forward and address our esteemed gathering.
Honorable Principal of this prestigious law college, Dr. Rohini Jagtap, my friend Mr. Prakash Salsingikar, Vice Principal of this college, faculty of this college and friends. It is indeed a privilege for me to address all of you for various reasons. I am aware that SNBP college is a very prestigious law college catering to the need of law students in this area. Secondly, I am also privileged to address the students and other faculty members in Pune district, particularly in view of the fact that the first draft of Uniform Civil Code was penned in Pune itself by Dr. Satyaranjan Sathi, who was earlier principal of INS Law College. Now turning to the subject of today's seminar, every one of us is aware that the Law Commission of India has invited suggestions from everybody regarding feasibility of Uniform Civil Code. Even earlier reports of the Law Commission would depict that in the year 2017-18, the Law Commission had earlier examined this subject. The Honorable Supreme Court had time and again exhorted the government to take fruitful steps for implementation of Uniform Civil Code. And in one of the judgments, in the case of Shahabano, when the Supreme Court discussed Article 44 of the Constitution of India, it felt the need, and this was a judgment by Constitution Bench, headed by then Chief Justice Chandrachud. In that judgment, when the Honorable Bench was discussing about need of Article 44, it was said that this should be brought earlier. One advocate whispered that legislative competence is a different thing and political will to bail the cat is a different thing. What he meant is that the Constitution has made provision in Article 44 for Uniform Civil Code, but it is not being implemented. And for that purpose, in spite of prodding by the Honorable Apex Court time and again in number of judgments, the leadership was not willing to do that. We are really fortunate that after the notification issued by Law Commission, our beloved Prime Minister in a speech underscored the need of bringing Uniform Civil Code. And this is the approach of the political leadership which was the need of the hour and which gives hope to us that Article 44 will not be only a dead letter in the Constitution of India, but it will be definitely implemented soon. When we think of any act, there are various aspects. First is that whether such act is needed. What is the rationale behind taking away or bringing a new legislation? The basic idea of Article 44, according to me, earlier it was said that there were two objects. One is the national integration and another is gender justice. According to me, now there is absolutely nothing to worry about national integration. The only thing we should be concerned about is the gender justice. And if we look at the plight of women in India, the need of uniform civil code can hardly be debated. In Shaira Bano's case, the plight of women who suffered triple talaq was brought to the fore. And it was pointed out that only on uttering a word talaq for 3 times, the relation between the parties come to an end. Is it so simple? Should it be so simple? Should it be so atrocious that nuptial ties between the husband and wife come to an end only on whims and fancy of husband can that be so? Then there are provisions in various acts which say that woman will be entitled to half of the share to which his brother is entitled. If a brother is entitled to 10% share in the property, woman will get only 5% share. So is it not offending Article 14 of the Constitution of India? Is it not discriminatory? So all these things are there. The Honorable Supreme Court in Sarla Nichols case, in earlier many cases, the Honorable Delhi High Court in even recent case in the year 2023, always said that there is need of enacting a uniform civil code. Unfortunately, on account of lack of political will, this was kept on back burner. And here I will borrow few lines from a Hindi poet who said that दर्द कहाँ तक पाला जाए, युद्ध कहाँ तक टाला जाए, तू भी है राणा का वंशज, फेंक जहाँ तक भाला जाए. For how many long years we will tolerate this dard? And therefore, this entire journey is from dard to Humdard. And there comes the organization of my dear friend Prakash Salsingikar. We can't tolerate this injustice made to women. And therefore, time has come to now come openly and say that yes, we stand for uniform civil code. And therefore, my first request to all of you is that please go on the site of Law Commission of India, register yourself, say something in support or you may say something in opposition of the Uniform Civil Code. But we are stakeholder in this entire process. So every one of us will be vocal, we must come out in the open and support what is envisaged by the constitution makers. And what they did, if we go to the Constituent Assembly debates, very interesting snippets will be found. A subcommittee was formed for framing of directive principles of state policies. Therein, by majority it was decided that Uniform Civil Code should not be included in the Constitution of India. That are the majority decision. 3 members, Mrs. Kaur, then Binu Masani and another person gave a dissent note, and therein they said that one of the reasons why India is backward is because of these archaic personal laws. These regressive personal laws are keeping us regressive, and it is need of the hour that Uniform Civil Code or Progressive Civil Code must be brought in at the earliest point of time. And in the dissent note they said, it is a part of record, that we rather suggest that Uniform Civil Code should be brought within 5 to 10 years. Unfortunately, that was not done. When this recommendation was taken to the Constituent Assembly, there also very heated debate took place. Many people suggested amendment to the provision and said that it should be left optional for the citizen. Somebody said that it is infringing our fundamental right to practice religion, that is protected, and therefore it is not necessary. Everything was said. Then Mr. K. Munshi gave reply to it. He pointed out that actually it's a myth that in India Muslims are governed by Sharia. They are not governed by Sharia. They are governed by Muslim Sharia Act 1937, which is enacted by Britishers. So it is not that it's a divine law, therefore it cannot be codified. It is already codified. He also pointed out that prior to this act, many people in India who were professing Muslim religion, such as Khoja, then Memon, Kachi, they were actually governed by Hindu law. You will be shocked to know that some Muslim communities were governed by Hindu law, and by this act they were taken out of the jurisdiction of Hindu law and thrown into the jurisdiction of Muslim personal law. He raised a question in the Constituent Assembly and asked whether permission or consultation with these communities was held. The emphatic answer was no. And then he said that if at that point of time, for inclusion of these communities, you don't consult them, you don't take their consent, what is the necessity of now doing so? And then he went on to give the example of Alauddin Khilji, who was a devout Muslim, but was not a very good ruler. He was known for his despotic style of functioning. At a time, he issued one certain direction. One Qazi raised objection to those directions and said that your law is against the principles enshrined in Quran. And there, Alauddin Khilji said that God is great, and it is really great. God will forgive me if I did something in the interest of my people. And later on, K. Munshi raised the question that if Alauddin Khilji can pass an order which, according to Muslim clerics, is contrary to the directions contained in Quran, why the Constitution of India cannot do so? Why it cannot be done, sir? Then Alauddin Iyer, he also participated in the debate, and he pointed out that many laws, as Madam also pointed out, such as Contract Act and other acts, they are applicable for every one of them. everyone, every Indian. And he said that there are verses in Quran, even regarding contract, on other subjects also. You have no objection if Indian Contract Act is enacted. And then why you are raising objection for all these things? And naturally, thereafter, Bharat Ratna Dr. Babasaheb Ambedkar gave reply to all this. And he also pointed out that Uniform Civil Code is the need of the hour. And he also endorsed the pleas of K.M. Munshi and Iyer. Later on, he said that, I suggest that in the beginning this should be made optional, and later on we may think of going for mandatory imposition of this act. Then later on, for the first time in the debate of Constituent Assembly, the recommendation of majority of the subcommittee on directive principle was negative, and the minority view of 3 members of the subcommittee was accepted by the Constituent Assembly, and therefore the present Article 44, which was then Article 35, was enacted. And what it said? It only said that at that point of time it said, state shall make an endeavor. What it said? State should make an endeavor. What is the significance of directive principle of state policy? Actually, if we borrow the popular phrase, in my humble opinion, directive principle of state policy is nothing but the Zahirnama of Constitution of India. Because in the directive principle, it is said that students below the age of 14 years should be given free and compulsory education. That was then enacted in Article 21A. Then directive principle also says regarding equal pay for equal work. Otherwise, women who are working equally or more than men used to get half of the salary or half of the wages as compared to men. Then it is said regarding various labor laws. All these things are being implemented. They are translated into certain legislation. There is also mention of cow protection. Many states have enacted laws to that extent. Therefore, this is a manifesto of Constitution of India, and it is the bounden duty of every state, every government to implement this manifesto. Otherwise, what is good of the manifesto? A political party releases manifesto and then reneges on it, retracts from all the promises made therein. Is it a good thing? What is said in the Constitution of India must be taken to its logical conclusion. And therefore, our subject today is that constitutional mandates of Uniform Civil Code. And I invite attention of this August gathering to the word mandates. Article 44, what mandate means? Mandates. It is plural. Article 44 is not the sole repository regarding gender justice. It is not the sole repository to say that there should be equal treatment to everybody. As I pointed out, there is Article 14. In Article 13 it is said that any law or anything which is contrary to the provision of Constitution of India shall be declared as unconstitutional. So if anything is there which makes discrimination between men and women, cannot stand the scrutiny of Article 13 of the Constitution of India. And that is what is said time and again. I am aware that even Madam also raised the question of religious freedom that is given in Article 25 of the Constitution of India. This Article 25 is time and again interpreted. This doesn't mean that state cannot interfere in the interest of public or for secular activity. When the Cow Protection Act was challenged, a similar plea was raised that we have the religious right to sacrifice an animal or even a cow. That was negative, and it is said that you definitely have religious right to practice the religion, but that right must yield to other provisions of the Constitution of India, and that is the directive principle of state policy, and therefore those laws were held to be legal and constitutional. That right is not absolute right, and therefore what is necessary is that every law should be equal to everybody, and that is the mandate of Constitution of India. Now many questions are being raised. Why now? The answer is very simple. Why now? Because till now it was not done. What is wrong if belatedly a provision in the Constitution of India is implemented? What is wrong in it? Actually, this should have been done within 5 to 10 years itself. That was not done. On the contrary, what was done, and that is laudable. In the 1950s, Bharat Ratna Dr. Baba Saheb Ambedkar brought before Parliament Hindu Code Bill, and there was very much controversy. Even the then President Dr. Rajendra Prasad had reservation about it and had said that he will not sign on this act. And what Dr. Ambedkar did, and every one of us will be thankful to Bharat Ratna Dr. Baba Saheb Ambedkar for bringing this Hindu Code Bill. We are aware, and in law schools I don't know whether the Mitakshara, Daya Bhaga, they are now taught or not. They may be taught, but their relevance is zero now in your Hindu Code Bill. In Muslim law, it is said that marriage is a contract. Similar provision is there in Christian Marriage Act. On the contrary, the belief of Hindus was that marriage is not a contract, it is a sanskar. And therefore there was no provision of divorce in it. So it is said that if you are married, then for 7 births, the same pair will be there. So what are the effect? Whatever the atrocities are committed, whatever sort of harassment is inflicted on a woman, she is not entitled to claim for divorce. And that was the thing. Hindu law was interpreted in various parts of countries in various manners. For succession, something different was there. For adoption, some different thing was there. And while piloting this Hindu Code Bill, and in subsequent interview also, the then Prime Minister said that by Hindu Code Bill we brought 85% of the Indian population under one law. So very Herculean task of bringing a majority of Indian population under the purview of a relatively progressive law was done in the 1950s. No doubt it was opposed by many persons, but that was implemented. And recently there are amendments in the Hindu Succession Act whereby now women are given equal share to that of the male also. Section 6 amendment. Maharashtra had earlier such amendment in section 28A. So all these discriminations are being wiped out slowly. The question is that what is done in these 75 years? In Sarla Mudgar's case, in the last paragraph, Supreme Court issued notice to the Union government and said that file affidavit before us and explain what steps you are taking for implementing the Uniform Civil Code. But that was in the year 1995. Nearly 30 years have lapsed. So can an injustice be tolerated for such a long period? It cannot be. And it should not be. Then another question is raised that it is not feasible, it is not practical. I would like to give you an example from our own country. In our neighboring state, Goa, there is Uniform Civil Code. And that Uniform Civil Code is in operation since more than 350 years. Goa is a Christian majority state, also having our Muslim brothers therein. So what was the problem there? Did they object to it? Whether there were any difficulties in implementing Portugal's civil code? There were no problems. I am aware that certain reservations are also raised, are there regarding some provisions of Portugal's civil code. In every law there are deficiencies, bound to be deficiency. We can amend them and if necessary we can change also them. That's a different thing. And one very important feature of this Goa Portuguese civil code is that when you perform marriage, the husband and wife are given the choice to enter into an agreement to say that what they intend to do regarding their property. The earlier property owned by husband and the latter property that will be purchased or earned by husband and or jointly by husband and wife. They can reduce it into writing. That is being implemented very smoothly. So if Portuguese civil code can be implemented in India, why not Uniform Civil Code? Then another objection is raised that what will happen to our religious rights? They don't understand what we mean by Uniform Civil Code. The first thing is that you are entitled to enjoy all your rights. You can perform marriage as per your religious belief. You can go to Gurudwara, perform marriage as per the Anand Marriage Act, which was subsequently abolished also. You can go to church. You can go to a Qazi and perform the marriage. Or you can undergo the Saptapadi and other sanskars that are given in Hindu custom. No objection regarding that. What will happen is that after performance of the marriage must be compulsorily registered. And why it is to be registered? Because then it will be on record that who is wife of so and so person and who is husband of so and so woman. This assumes significance because a very interesting question arose before Honorable Supreme Court in Sarla Mudgar's case. We are aware that in India, for Hindus, monogamy is the rule, is the law. To circumvent this law, men resort to various tactics. When they intend to marry another woman, they simply convert themselves to, say, Muslim religion and get married. And then say that now I have to confine myself only to 2 wives. I am entitled to have 4 wives. And that was the controversy, that was the dispute in Sarla Mudgal case, and Honorable Supreme Court said that conversion only for the sake of circumventing the provision regarding monogamy is unconstitutional. And many instances are given in that judgment. So, you have to adhere to law. Then the question arises regarding divorce also. In recent judgment of Shaira Bano, Supreme Court by 3 versus 2 majority held that the practice of triple talaq is unconstitutional. And therein it is said that what is bad in theology is also bad in law. Because it is said that Quran or Prashid or Prophet Muhammad doesn't endorse this triple talaq practice. Justice Berman said that. Then it is said that this practice must go because this is atrocious practice. Then by majority it is said, or rather unanimously, the Union of India was asked to bring a legislation thereby delegitimizing or prohibiting the practice of triple talaq. Then the new legislation came wherein there are penal provisions which were also objected to by some section. This is not the only talaq practice, there is halala also. And what is halala? If a woman is divorced by her husband, and if husband again or husband and wife again want to remarry, then the woman has to undergo through the trauma of again solemnizing marriage with another person. Not only just solemnizing, consummating marriage, and then divorce that person, then she can marry her original husband. Can a civilized society accept such practices? No, but they are prevalent. Even triple talaq cases are, though banned, are happening day in and day out. In Maharashtra, in 1966, a big morcha was taken out on Mantralaya. How big it was? 7 women were there. Why I call it big? Because their demands were really big and great. In 1966, these Muslim women made demand that triple talaq be prohibited. Uniform Civil Code we brought at the earliest. That morcha was led by Amit Dalwai, and those 7 women really laid the foundation for bringing Uniform Civil Code. In Maharashtra, we have a very great legacy of social reform. We talk about, and rightly, Phule, Ambedkar, Shahu, and therein I would add even Hamid Dalwai's name. And what he was trying to say? He said that this practice is wrong, triple talaq should go, there should be common law for every Indian, and other things are there. Therefore, the another aspect of Uniform Civil Code is that you have to marry and it should be registered. Divorce will be only through the decree of a civil court. Otherwise, divorce before Qazi, divorce before Padri, divorce before Pujari, divorce before notary public is non-est, is ab initio void and illegal. Otherwise, there will be anarchy. A person will say that 3 months ago I said once talaq, then after 1 month I said talaq, and then after 3 months I say talaq. And then it is talaq, talaq, talaq. That should not be there. Otherwise, Muslim woman or even Christian woman will face many difficulties. For getting divorce, the earlier provisions were that Christian woman will have to make allegation against her husband of indulging in adultery. Otherwise, divorce was not possible. What is the necessity? The Honorable Supreme Court is saying that irretrievable breakdown of marriage is also one of the grounds. It is not a 7-birth affair now. Whether it is right or wrong, one may debate, but legally speaking, this is the law of the land and that must be followed. And therefore, there must be provision regarding divorce also. Now turning to another aspect of Uniform Civil Code, it will be only limited to certain portions: marriage, divorce, maintenance, adoption and succession. As far as maintenance is concerned, many of you may be aware, may not be aware, that there is a provision in Criminal Procedure Code, section 125, wherein woman is entitled to get maintenance from her husband. That provision is not applicable to Muslim women. Muslim women are entitled to get maintenance only for the period of iddah, and she can only claim that meher, the amount that was agreed upon between the parties while entering into marriage, will be returned. Later on, after judgment of the Honorable Supreme Court, there was huge outrage by the orthodox people. Then government succumbed to their demands, and then another act was brought, thereby nullifying the effect of Shah Banu's verdict given by the Honorable Supreme Court. So why 125 or maintenance provision should not be applicable to Muslim women? Are they self-sufficient? Can they maintain themselves? No. And the provision in the newly enacted act is that what, or rather state will have to make provision for maintenance. Why we should pay for maintenance as a society? There is a personal relationship, there are problems in your personal relationship. So either you pay or you don't pay and you face the consequences. That provision is done away with, and therefore it is need of the hour that similar provision must be made in the Uniform Civil Code. Regarding adoption, it is said that Quran does not permit adoption. There are contrary claims to that effect. I also consider that fact. But the fact remains that during his lifetime, Prophet Muhammad had also adopted a son. That is one aspect. And secondly, that if we make provision regarding adoption, will it be mandatory for every person to adopt girl or a boy? It is not mandatory. A uniform provision will be made. You may go for it, you may not go for it. It will not affect any of your religious rights. For adoption also, there should be very proper and progressive provisions, because nowadays it is seen that people are not marrying. There are issues of not being able to give birth to a child. How to overcome all these things? And on the other hand, there are anath ashrams wherein hundreds of children are languishing in the hope of getting the help of or the benefit of a family. They are denied the benefit in view of the prevailing social problem. Even the provision of adoption must be there. And regarding succession, as I earlier pointed out, that there should be uniform provision every woman will be entitled to get share equal to his brother. Many doubts are raised as to whether woman should get share in the property of his father or from maternal side and paternal side and of her in-laws also. These things can be ironed out. These are not very difficult things. There are customs in various communities regarding prohibited degree of marriage. Those also can be taken care of, and I pointed out that Dr. Sathe had prepared a draft. Therein care is taken to redress all these grievances. So it is not that Uniform Civil Code cannot be drafted. It is not that it cannot be implemented also. A myth is being spread in India that if Uniform Civil Code is enacted, it will affect reservation. There cannot be a bigger lie than this myth. Uniform Civil Code has nothing to do with reservation that is given by way of positive discrimination theory, and that will stay. Uniform Civil Code will be confined only to marital affairs and consequential things such as succession, adoption, etc. Therefore, there is absolutely no truth in what is being said in opposition of Uniform Civil Code. It is said that by Uniform Civil Code you are trying to impose Hindu traditions on every one of us. This is a laughable propaganda, because if you will go to Hindu code bill, whether anything Hindu remain in that, we will take away the joint family, we will take away the concept of marriage as a sanskar. Even Hindu code bill now is totally secular, and therefore there is absolutely no problem if that is there. And if your reservations or if your apprehension that Hindu thoughts will be imposed on you, or majoritarian thoughts are being imposed on you, you can oppose particular clauses in the act. You are entitled as a democracy. You can say that this is not proper, this is Hinduization of India. You can oppose that. But you are not ready for that. What you say that we are opposed to it, don't bring it. That is not proper. Some people like Shahabuddin used to say that bring the draft, then we will discuss it. This is also not proper. Because what the Constitution mandates us is that state shall make an endeavor. An endeavor means that a consensus should be built across India regarding enacting Uniform Civil Code. If such consensus emerges, it's a matter of couple of hours to draft Uniform Civil Code. And there are many drafts. Retired Supreme Court Justice Thomas, with the help of some law universities and law colleges in Kerala, had also prepared a draft. There are many drafts. 5 years ago, progressive lawyers, writers have also submitted draft to the Law Commission, which is not more than, it consists of not more than 15 sections. It is such a simple thing. Now another canard is being spread that you are bringing this law only keeping in mind the Muslims. On the contrary, this law will adversely also affect Hindus. And it is said that then what will you do of tribals? No doubt, the question of applying Uniform Civil Code to tribal is very, very complex. Because even in tribals, there are sub-tribals, there are various communities which are differing even as far as their custom of marriage, etc. are concerned. We brought nearly 85% population by Hindu Code Bill under Uniform Code. Let us go a step further and bring another 10 or 12% of population under the purview of Uniform Civil Code. Then we can go a step further in future. For the present, we can keep our tribal brothers outside the purview of Uniform Civil Code. That can be done. Then another objection that is taken is that now you are saying about triple talaq, etc. What will happen to your tax exemption you get under the head of undivided Hindu family? Now, this is also very laughable opposition. I got these statistics and it said that around 12 lakh people are having HUF accounts. Only 12 lakh people. I don't know what is the exact population of Pimpri-Chinchwad, but it must be more than that. So, can we defer enacting a progressive law on the ground that it will affect 12 lakh people? And don't worry, the policy maker, the intellectuals, and the protectors of Constitution of India will persuade even Hindu community people having HUF account to forego that benefit for the sake of gender justice and for the sake of this nation. So that is also absolutely useless opposition to the proposition of Uniform Civil Code. On all these counts, it is high time that Uniform Civil Code be brought. We can debate on the clauses. The thing is that nation should make up its mind. Now political leadership had taken the initiative. It is ready. There are two ways of doing this thing. In the earlier round of their consultation, the Law Commission came out with suggestions saying that instead of directly going for Uniform Civil Code, let us do it in compartments. Let us first include gender justice clauses in all personal law. I have absolutely no objection for that. Because Uniform Civil Code does not mean that identical civil code. It need not be. Uniform means that there should not be discrimination on the ground of religion. There should not be discrimination on the ground of gender. There should not be discrimination on the ground of income or your place of residence. If that is also done, personally I have no objection. But then, this is also very difficult. Then also it will be said that now you are including in our personal law fiefdom. Don't enter here. It is a divine law. Parliament doesn't have any jurisdiction. We need to meet these objections, and therefore, as I said, nation will have to wage an intellectual war. युद्ध कहाँ तक टाला जाए? How long we will avoid the war? This is an intellectual war. This is a constitutional war. We cannot shirk away from the responsibility of winning this war. We will have to do that, and for that purpose, we must, every one of us, support the idea of UCC. I am aware that I think I have consumed more than allotted time. I will conclude by reciting few lines from a poem of noted poet Taslima Nasreen, wherein she said that 100 साल बाद यह कविता कोई न कोई पढ़ेगा जरूर. वहां अगर स्त्री हो तो क्या वह केवल स्त्री ही होगी? मान लेती हूं कि कोई स्त्री नहीं, तब वह सिर से पांव तक मनुष्य है. तब वह चार दीवारी में कैद नहीं होगी, उसके पैरों में पिछले हजारों सालों से पड़ी ये जंजीर थी, वह नहीं होगी। उसके हाथों में जो क्रोशिया, सुई और सलाई थी, नहीं है। हाथों में कलम, हंसुआ, कुदाल और कलपुर्जे। वह मनुष्य की तरह चलती है, दौड़ती है, जोर जोर से हंसती है। वह कुपोषण से ग्रस्त भी नहीं होती। वह अगर स्त्री है, उसे कोई स्कूल न भेजकर झोंक नहीं पा रहा है चलती हुई अंगीठी में। उसे और पहनाया नहीं जा सका है बाल विवाह का फंदा। उसे अब ढका नहीं जा रहा है भूतहा बुरखे में। निश्चित ही अब वह मांग सकती है समान उत्तराधिकार। निश्चित ही वह मांग सकती है शिक्षा, स्वास्थ्य समान। निश्चित ही वह मांग सकती है कोख की स्वाधीनता, लड़की का जन्म। निश्चित ही वह मांग सकती है चांद और सूरज के नीचे अभिमान से रहने का अधिकार। I pray to everyone who is right to be upheld and fight for this right of woman to be made human being. I earnestly thank every one of you. Thank you very much.
So it was just amazing. I'm personally privileged to hear from you. So your words have settled deeply within all of us, leaving a lasting impact on us. Your profound insights into the legal world, coupled with your extensive experience